Thank you very much. And first of all, I would like to say good afternoon to all of you, and to say that I'm very happy that I back at the university where I graduated. So for me, it's a huge honor to be here, and I'm really honored by the opportunity that I can spend this afternoon with you. And just another off-topic comment for today, maybe that I'm very happy that we still have a few people in the room, although we had the lunch. So it's nice to see that maybe you're interested in the afternoon session as well. So for me, it's very, very, very nice to see. Okay, then let's move on to the topic. As a start, I would like to say that in November last year, the Commission has published the Digital Simplification Package, which is also known as the Digital Omnibus, which was kind of a response to calls to prepare a more competitive, a more innovation-friendly, and less burdensome digital environment. And together with the Digital Omnibus, the European Commission has unveiled the Digital Justice Package 2030, which has two major pillars. One of the pillars is the Digital Justice Strategy 2030, and the other one is the EU Judicial Training Strategy. And unfortunately, I do not have time to speak about all these three strategies in details all at once, but to be in line with the flow of today's conference, I thought that maybe the digital justice strategy would be the most relevant to share with you, because it's basically focusing on digitalization and the use of AI in justice. Yes, hold on for a second. Yes, the digital justice strategy, yes, and sorry for the not so fancy slides, but I'm not a very, I'm not so expert in PowerPoint. So the digital justice strategy is the EU strategic framework to accelerate the digitalization of national justice system by 2030. And the overarching purpose of the digital justice strategy is to improve the efficiency, the transparency, and also the quality and the resilience of justice system in the European Union, safeguarding the rule of law and what is mentioned many times today. First, it was maybe Professor Attila Menyhárt who mentioned the fundamental rights. The digital justice strategy largely built on the Digitalisation regulation, which is the legal framework of the digital tools that should be used in case of cross-border judicial proceedings and other digital tools like electronic payments, for example. And this digitalization regulation, which was adopted in 2023, has very strict guidelines and very strict tasks that should be followed by the member states. But to get back to the digital justice strategy, let me show you that the strategy has 7 work streams. These are the work streams that the Commission will focus on in the coming years and in the coming month. And let's start with the first one, which is the mapping and monitoring. In the past few years, the Commission, together with the member states and the presidencies of the Council, has launched many surveys, questionnaires about the use of digital tools and AI tools in judicial proceedings. So the purpose of these questionnaires was to know how the state of play of digitalization and the use of AI tools in the member states. And it became soon very clear that the situation is not so nice, because in most cases it is very difficult or complicated or simply impossible to find the relevant information on which tools AI softwares are used in the member states in judicial proceedings. Also, it became clear that although the member states are facing the same issues, the same challenges, if we are talking about judicial procedures, they don't know anything about each other's tools. So they have no information at all what tools are used in other member states. And finally, there were simply any central sites that would just be, let's say, call it a central source for information, or a central source that where the tools of the member states are used in judicial proceeding should be shared. And therefore, the Commission, together with the member states and also the presidencies, based on many discussions that we had, just said that a very clear program, which says that the Commission will create a so-called mapping exercise, or a kind of a collection of information about the best practices and the justice-related projects of the member states that are related to judicial proceedings. And the other key findings of this discussion was that the Commission will establish a so-called living repository, which is would serve as a let's say a storage for AI or IT tools, which could be the central point for the member states, where they can share their AI tools or IT tools that is used in their court procedures. And let's see that how this living repository of this website will look like sometimes in the near future. So on the first screenshot, you see that this is the proposed outlook of the website. So you see that in case of living repository, we are planning to group the different IT or AI tools into certain categories based on the purpose of the tool. And if someone will click, for example, a category, then another window will appear where there will be a short description about the tool, what can it be used for, about contact details of the persons or the department where they can turn to if they need more information about the usage of the tools, or how it can be used efficiently. And also there will be a direct link, because if it would be a open source software, for example, then this direct link will lead to that site where that software can be downloaded from. So the concrete actions that will be taken in the coming years by the Commission is to establish this living repository, to host IT tools and AI tools of the member states on the e-justice portal, hopefully by the end of 2026, which is this year. And now we are already discussing about the tools, and we have already received some AI tools from the member states, which will be published very soon. And the action 2 that will be taken very soon by the Commission is that also a center of mapping exercises will be created also, just to share the information of best practices and justice-related projects. Now let's move on to the second work stream, which is IT Toolbox. The IT Toolbox, at first sight, looks very similar to the living repository, because the purpose of this IT Toolbox also is to host softwares and IT applications that can be used in judicial proceedings, but there are certain differences between IT Toolbox and the living repository. But the purpose is nearly the same, but this IT Toolbox will be hosted by the interoperable portal, which is a completely different portal like the e-justice portal. And let me show you how it should look like. So this is the screenshot of the IT Toolbox. It's far from finished, but we would like to launch this site very soon. And I just mentioned a few minutes before the differences between the living repository and the IT Toolbox. And one of the differences is that, what I just mentioned before, that this living repository will be hosted by the e-justice portal, while the IT Toolbox will be hosted by the interoperable portal. The second main difference is that the IT Toolbox will have the repository of only open source software, while in case of the living repository, it will host not just open source software, but proprietary tools as well, which has license fees or purchase fees as well. And the third main difference is that in case of the IT Toolbox, there should not be any restrictions to access to the contents on the portal, while in case of the living repository, is supposed to have some kind of access limitation to courts, to legal professionals. And the reason that we are planning to introduce this kind of restrictions, based on the discussion with the member states, because they thought that maybe it would be better if we keep this source of information just for those experts who are dealing with judicial cases, or who are working in courts, or any other legal professionals. So the action that is linked to the IT Toolbox is that the Commission will create this site, this portal for the IT Toolbox by the end of 2026. And let's move on to the third work stream, which is AI in justice. The use of AI in digitalization and of course in the court proceedings is increasingly being used all over the world, and the courts are under high pressure or heavy pressure to reduce the delays and also to improve the access to justice and to handle a large number of cases. And therefore, the concept between the AI tools in justice was to support the work of the court staff, the judges, but not to replace them. And I think it's very important to mention, which is absolutely in line with the conclusion of the Hungarian presidency, that the AI tools in justice, in judicial proceedings, should be a supportive tool, but not a replacement tool of human interface. And at this point, let me give you a few examples about AI in justice, which is, for example, in the Brazilian Supreme Court, the court is using AI-driven tool called Victor, and which has nothing to do with our Victor. And this Victor tool, the purpose of this tool is to check the appeals that sent to the Supreme Court, whether it meets the basic legal requirements. So you can see that this automation, this automated tool can save a lot of time on routine tasks. Another good example for the use of AI is the example of Slovenia, where they use AI-driven tools for transcription, which means that the sound recordings of the codes automatically converted into transcript, and it's much easier to search in the database of the codes. And of course, we have some good example for the bad example, which comes from the US. In October last year, in the courts of New Jersey and Minnesota, there was a kind of scandal because after many hundreds of court orders were issued by the courts, by the Minnesota court and by the New Jersey court, then more and more complaints arrived to the courts by people who were mentioned in the orders. And the problem was that the orders and the court decision contained absolutely irrelevant data. And to be more precise, those court orders included names of people who were not parties to the trial. The orders also included absolutely incorrect legal references to certain legislation or certain cases which simply did not exist. And that was the problem which is caused by AI hallucination, that the court staff used AI to prepare those court decisions, and it wasn't supervised by human interface. And that's why I think it's very important that the Commission is planning to issue guidelines about the use of AI in court proceedings to see where, how, and when is it recommended to use AI in justice. And also the Action 2 is very similar to Action 1, that we are planning to have many discussions with the member states and relevant stakeholders, how they can, just to facilitate them, in the uptake of AI in justice. And these two actions will be taken, I think, in this year and maybe next year as well. And the fourth work stream, and actually I plan to talk about it on the first four work streams about digital strategy, because they are the most relevant to today's conference. And I have only 2 minutes left. And the fourth work stream is the video conferencing. And when we are talking about court trials, we usually think of it as a court, the in-person trial. But in case of cross-border proceedings, the situation is completely different. Because in those court cases, the parties of the trial are located in different countries or different premises. So in this case, video conferencing can help to hold a remote trial if the participation in person is not possible for various reasons. For example, let's say for security reasons, because there's a pandemic, or some other thing which just hinders the in-person trial. And in case of domestic trial, there is no issue at all, because usually the courts are using the same IT tool, the same video conferencing application. But in case of cross-border judicial proceedings, the member states are using different types of software, like Microsoft Teams or WebEx or Zoom, which are completely incompatible with each other, so they cannot interconnect with each other, and therefore it is not possible to hold a remote trial. And therefore, the member states asked the Commission to provide certain technical requirements for video conferencing, which can help to develop such type of software which could overcome this interoperability problem. And the action too that will be taken by the Commission in the near future is that it will launch a study to observe, to explore the possibility to develop, and it's very important, to develop an EU sovereign solution for video conferencing. Because now there is a huge pressure from the member states that we should use EU tools for EU processes, and therefore the Commission will take it on board, and we will launch a study very soon about this video conferencing solution to find or develop EU sovereign video conferencing tool. And yeah, then I have to finish, but I think I covered all the relevant part of digital strategy. And just one last comment that I think you just mentioned that there are no any planned legislation related to the digital justice strategy, and it's because member states made it very clear that they don't want more legislation. Because they have to focus on the implementation of the existing legislation, and they have no time, no capacity for new legislation, and that's why we are thinking about only in administrative tasks and steps in the future. Thank you very much for your attention.